All right. Good morning, ladies and gentlemen. My name is Judge Lal, and we're going to begin with our state all-purpose calendar. I do apologize for this delay, but we will get cracking with our cases. This is a list of misdemeanor criminal cases in which individuals have already been charged with one or more misdemeanor offenses. When I address your case, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you will be either a private attorney or counsel from the public or conflict defense list. Okay, I have courtroom 2, courtroom 3, and 5 south. Who would like to be addressed first?
Hi, good
Position,
morning.
position 27,
Position, is it in
27,
27 in which location?
wait a minute.
In courtroom 3? Okay. Let's see now. This is Mr. Quentin Wilson, represented by Ms. Catrice Helen. Mr. Wilson, you've been advised of your right to remain silent. Your case number is 18 CR 001-875C, and this is going to be a negotiated plea. May I raise your right hand, please? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Speak up.
Yes.
All right, thank you. Mr. Who's our prosecutor, please? Do we have an ASG?
Your Honor,
Ms.
I'm here
Allen?
as the supervisor this morning.
Okay, Ms. Allen, we are addressing position 27. Do you have anyone who can articulate the plea for this case?
I can, Your Honor.
Okay, go ahead.
1 second. Ooh. This is Bianca.
No, this is
No.
Wilson,
Okay, excuse
Quentin
me.
Wilson.
So, Your Honor, the charges in this case are brake light, turn signal violation, unregistered vehicle, operation of a vehicle without current license plate, and decal, suspended and revoked license, and DUI, as well as giving false information to a law enforcement officer. This is an incident from February the 18th. It says 2016 on my documents.
It's
This
2016
occurred-
incident, yeah.
Yep, Joseph E. Boone Boulevard.
Right, so
Um,
this is a negotiated plea. I believe y'all are making an offer concurrent for all charges. What's
Yes,
that
Your
offer?
Honor. 12 months to serve, 48 days, credit for time served, 24 days, balance probated, $300 fine, and some other specifics that I believe we've communicated as well, all counts to
All right.
run concurrent.
I have risk reduction, alcohol and drug evaluation and treatment if required, 40 hours of community service, and 1 victim impact panel. Is that the offer you received, Ms. Helen?
Yes, Your Honor, good morning. That is
Good
the
morning.
offer we've received. We do accept that offer on behalf of Mr. Wilson, and we do stipulate to the factual basis, venue, and ID.
All right, thank you. Mr. Wilson, have you consumed any alcohol or drugs recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Excuse me, beg your pardon. And Mr. Wilson, are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea offer today?
No, ma'am.
Your attorney has gone over all the rights that you would have to waive if you want to plead guilty to these charges. In
Yeah.
doing so, you will waive your right to a trial, to confront your accuser, challenge the state's evidence, present your own defenses, and have the state try to prove the charges against you beyond a reasonable doubt. These are some of the rights that your attorney went over with you. Are you prepared to waive them?
Yes, ma'am. I want to go ahead on and do with the case right now.
Understood. So when your attorney sat down with you and said, if you were going to plead guilty in exchange for a negotiated offer from the state, paying a $300 fine, going on probation, doing an alcohol and drug evaluation, community service, and so forth, she also went over all your constitutional rights that you would have to waive, give up in order to take this plea offer. Do you recall that conversation?
Yes,
Are you prepared to waive these rights?
yes,
How do you plead? To brake light or turn lights violation, operating a vehicle with without the current license plate or decal, suspended or revoked driver's license, DUI under the influence of drugs less safe, and giving false information to an officer.
plead guilty.
Your sentence will be concurrent for all charges, and it is 12 months to serve 48 days, credit for time served 24 days. The remainder of time is probated. Once you are released, you shall report to the probation office at 132 Mitchell Street within 7 days, and you will report to that probation office to set up your probation case. While on probation, you will pay a $300 fine, complete a risk reduction, complete an alcohol and drug evaluation, and submit yourself to any treatment if required. 40 hours of voluntary community service at any nonprofit agency, and complete one victim impact panel. Your probation officer will recommend to you the appropriate programs that would qualify for probation. Do you understand?
Yes.
All right, that is your sentence. This concludes the case. Thank you.
Everyone.
All right, Bogle, do you have any more cases in courtroom 3?
Okay.
Hold on, Bogle. Just 1 second, Francois. Bogle, do you have any more cases in courtroom 3?
I do, position 22. We can go to courtroom 1 real quick and come back.
Okay,
I got
all
it.
right, courtroom 2, who do we have, please?
This is gonna be position 14, Mr. Longhorn.
Thank you. This is Ronnie Longhorn, and who is representing Mr. Longhorn?
That'll be Mr. McLean. It seems he walked away from his desk. I'll just give him a call.
Okay. We're waiting on defense counsel to appear for Mr. Francois, did Mr. Longhorn require a breakout with Mr. McLean?
Not that I'm aware of. You didn't mention anything.
That's an Antonio Jacobs also. Have Jacobs and Longhorn spoken to Mike McLean? Mr. McLean? There he is, he's back. All right. Mr. McLean, good morning. If you could unmute your screen, please.
Thank you. Sorry, I had stepped across the hall to grab the printout.
No problem. Have you spoken to your client, Ronnie Longhorn and Antonio Jacobs?
Those two I have not. I need a breakout for them.
All right, you would need to call the jail at 404-612-2392 and speak to them on the phone. All right.
Very good.
That would be for position 13, Jacobs, and position 14, Longhorn.
I'll
Position-
mute myself now to do that if that is.
Okay,
good time.
just hold 1 second, sir. Courtroom 3, who do you have?
Position 22.
All right, that's Miss Helen. All right, Mr. McLean, this is a good time to call.
Thank you.
We have Rico Robinson accused of criminal trespass from August 25th, 2022 in case 22 CR 007062J. Mr. Robinson, you've been advised of your right to remain silent, and your attorney is Miss Helen. Miss Helen, this is going to be an arraignment.
No, Judge, for
No,
position
it's a
20
negotiated plea.
Yes, Your Honor, correct.
Sorry, read the wrong line. Okay. And Mr. Robinson, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. As I said, you've already been advised of your right to remain silent. Ms. Allen, what's the state's offer? Would you like me to read the offer that was provided by the solicitor's office?
No, Your Honor, I have it. The state's
Okay.
offer in this case for one charge of criminal trespass is a 12-month sentence with service of 60 days, credit for time served, balance probated, an anti-theft class, 60 hours of community service. And it looks like a substance abuse evaluation and no further contact.
I believe that's a stay away from the incident location, Judge.
Yeah, the SA stands for stay away, but that's a
Thank
good
you.
acronym for substance abuse as well. Okay. All right, thank you.
It's the property of Carl Ford at 1251 East Forest Avenue and Winburn Terrace in East Point.
1251,
Yes, I believe so.
1251 address, please. I'm sorry.
Forest Avenue and Winburn Terrace, that's the location.
Forest Avenue.
And who was the victim?
There's no victim.
They had enough further contact with someone.
Who are you asking him to have no contact? With
The
whom?
property of Carl Ford, Karl.
Was it a car
F-O-R-D.
dealership?
Yes,
All right, I'm just going to put a stay away from the Carl Ford dealership at that location. Okay. Miss Helen, do you stipulate to the factual basis, venue and ID? Are those the terms to which your clients agree?
I do, Judge, and I do stipulate, this is a probated sentence, Judge, so we are asking for those probation fees, at least 4 months to be waived for Mr. Robinson, to give him an opportunity to do the 60 hours of community service. And Judge, once he completes that class or the community service and the anti-theft class, we'd like to ask if it can be non-reporting, if the state is amenable.
Any objection to non-reporting after 4 months or after he's completed the terms?
no, Your Honor.
Okay. Mr. Robinson, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
And you do understand that if you decide to plead guilty to this charge, you would have to give up your right to a trial, to go back to court and confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass?
Yes.
Repeat.
Yes.
Your sentence is 12 months to serve 60 days, credit for time served 60 days. If you have no other cases holding you at the jail, you will be released and report to probation next Thursday at 132 Mitchell Street. While on probation, you will, your first 4 months of probation fees shall be waived, and that will include November, December, January, and February. So I recommend that you try to complete all your conditions by the end of February 2023, and this would include an anti-theft class at your expense, 60 hours of voluntary community service, and once you've completed these items, your probation will be non-reporting. At all times, you are to stay away from the Carl Ford dealership at 1251 Forest Avenue. I think it's in Atlanta, Georgia. Okay, thank you. All right, Mr. Lawhon in courtroom 2, are we, Mr. McLean ready, or is he still talking to Mr. Jacobs?
He's still on the phone.
Okay, then I'll move on to 5 South. Who do we have?
Position number 21,
Okay, this is Elijah Malik Rahman, accused in 19 CR 009694Y of theft by receiving stolen property, sealed belt violation, driving without a valid license, and willful obstruction of an officer. This was from a January 17, 2019 incident. All right, 2 things. This appears to be an arraignment, but I have a note that it's been transferred to Superior Court. Ms. Allen, do you have any updates?
Your Honor, that was a mistake in the documentation. This case has not been transferred. We conveyed an offer, and I believe this is just an arraignment today.
All right.
Your Honor, that is correct. That's what I have as well, that this is not a transfer and that today we're just arraigning this case.
All right, thank you. Ms. Helen, do you waive a reading of the accusation?
I do, Your Honor.
Thank you. Mr. Rahman, you've been accused of these 4 misdemeanor offenses from January 17, 2019, allegedly in Fulton County. Sorry, it's very dry in here. With regards to these 4 charges, you are presumed innocent, and upon your entry of a not guilty plea, the case will be scheduled for a trial before the division judge. At the time of the trial, the case, the state, that is the prosecutor, would have the complete burden to prove the charges against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and/or up to $1,000 fine for each convicted offense. Given this information, how do you plead? Mr. Rahman, how do you plead?
Guilty.
Not guilty because,
Not guilty.
correct, Mr. Rahman.
Mr. Rahman,
Not
are you
guilty.
awake?
Yes, ma'am.
All right, so as you've understood the proceedings and as I've discussed it with your attorney, I thought you wanted a trial in this matter. So if you are pleading not guilty, the case is going to be scheduled for trial. So
All right.
given the 4 charges, how are you pleading?
Not guilty.
This case has been arraigned and it's going to be further notice for trial. Thank you.
Thank you, Judge.
Francois, are we ready to proceed?
Yes, it's gonna be position 15, Mr. Lucius.
All right, that's Mr. McLean's case. He's not.
That's Helen's.
That's mine,
Yes.
Judge.
All right, thank you. Michael Lucius, position number 15 is going to be a negotiated plea. He's accused of forgery in the 4th degree from October 13, 2022 in 22 CR 006-888A. Mr. Lucius, you've been advised of your right to remain silent and your attorney is Ms. Helen. May I place you under oath? We need to unmute courtroom 2. So do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Allen, what's the recommendation?
Your Honor, the offer in this case is a 12-month sentence with service of 30 days and credit for the 15 days he's already served. The remainder will be probated. He's to take part in an anti-theft class and complete 50 hours of community service and then not return or have any contact with the victim or the property, which is the Regions Bank here, 600 South Central Avenue in Hapeville.
Ms. Helen, do you stipulate to the factual basis, venue and ID, and does your client accept these terms?
Yes, Judge, I do stipulate and I do ask the court to accept this plea as negotiated. It is a probated sentence. We are asking for those 4 months of probation fees to be waived. And if the state is amenable, can it be non-reporting when he completes the conditions?
Any objection, Ms. Allen?
No, Your Honor.
All right. Mr. Lucius, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
In accepting this plea offer, has it been explained to you that you would have to give up your right to a trial, to go back to court and confront your accuser, have the chance to examine the witnesses brought against you or challenge the state's evidence, as well as have the state try to prove the charge against you beyond a reasonable doubt? Has that been explained to you?
Yes, ma'am.
And are you prepared to waive your rights?
Yes, ma'am.
How do you plead to 1 count of forgery in the 4th degree?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other holds at the jail, you should be released within 24 hours. And you must report to probation next Thursday at 132 Mitchell Street in downtown Atlanta. I will waive your probation fees up to and including the end of February 2023, during which time you should finish your anti-theft class and your 50 hours of community service, after which then your probation will be non-reporting. At all times, you are not to return to the Region Bank at 600 South Main Street in Hapeville, Georgia. Understood?
Yes, ma'am.
Thank you.
Thank you.
Going back to position 14, Mr. Longhorn. Come on, Mr.
All right.
Longhorn.
Thank you. We have Mr. Ronnie Longhorn, 22 CR 005-682A, accused of criminal trespass from August 24th, 2022. Mr. Longhorn, you've been advised of your right to remain silent. Your attorney is Mr. McLean. Mr. McLean, how are you proceeding in position 14, Mr. Longhorn?
Mr. Longhorn is incompetent and needs to go to the competency calendar, Your Honor.
All right. Has he been evaluated?
I don't believe so.
All right, so I'm going to reset this out 4 weeks to be put on the competency calendar, and you will submit the appropriate paperwork
Very well.
for him to be evaluated. His next court date is going to be December 1st, 2022 on the competency calendar. Thank
Thank
you.
you. Thank you. Your Honor, number 13 will be available when he is gotten from his cell, I believe.
Oh, he's not available? Okay.
He is on a different floor. He's on 4, and when they stop doing 5 and start doing 4, they'll bring him out.
All right. Courtroom 2, who do we have, please?
Position 11, Holder.
Garion Holder is 19 CR 009333F, accused of criminal trespass on November 18, 2019. Mr. Holder, you've been advised of your right to remain silent, and your attorney is Mr. Mike McLean. And this is position 11. So that's going to be a negotiated plea. Mr. Holder, if you please let me place you under oath. Mr. Holder, I need to place you under oath in order to pursue this plea hearing.
All right.
Are you Garion Lynn Holder?
That's me, Your Honor.
All right. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I affirm.
Repeat.
I affirm.
Thank you. Ms. Allen, what's the recommendation for Mr. Holder?
Your Honor, for this one count of criminal trespass, the offer is time served, the balance obviously suspended, and to stay away from the incident location. That is a vacant building 422 at 5655 Old National Highway. That's the 4 building.
The 4 building?
Yes. Building 4.
Oh, I see. All right. Mr. McLean, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
We do, and he does.
All right, thank you. Mr. Holder, have you consumed any medication or alcohol?
No, I haven't, Your Honor.
Have you understood the proceedings so far?
Yes, I have.
And are you satisfied with your attorney?
Yes.
I'm sorry, repeat?
Yes.
All right, and if you decide to accept this plea offer, you would have to give up your opportunity to go back to court and have a trial, confront your accuser, be able to examine witnesses and challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
And how do you plead to one count of criminal trespass?
Yes.
Your sentence is time served. How many days? I'm trying to find his jailings on how many days he's been in custody. It's a state all-purpose calendar, position number 11.
Well, back in 2019, there were 2 days, but right now I'm not sure how many days in addition.
7.
I will also, Your Honor, I will sign the plea paperwork for Mr. Holder.
All right, just 1 second. He's been in custody, according to the jailing, for 42 days. So it would be 12 months to serve, I guess, to serve 84 days, credit for time served 42 days, balance suspended, and to stay away from the incident location. Would you agree, Mr. McLean?
Yes, Your Honor, that does sound like the number of days he's been in.
All right.
He has something else holding him, so he'll have to wait to go until that's over.
Mr. Holder, your jail time for this particular case is concluded. So if you have other matters that are holding you in the jail, you'll have to address those separately. But otherwise, your obligations for this case is over. Thank you.
Thank you.
Position 12, Irons.
Sharif Irons,
Yes, ma'am. Good morning, Judge.
good morning. Mr. Irons, your case number is 22 CR 006909F, accused of battery and willful obstruction of an officer from October 13, 2022. Mr. Irons, you've been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath for purposes of the plea?
Yes,
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Allen? I'm sorry, you're on mute, please.
Thank you. The offer in this case for 2 charges is 12 months, 30 days to serve, credit for time served already, which is 8 days, I believe, balance probated. There's a 12-week anger management class, no further contact, and stay away from the incident location. This is Georgia State University. Let's see.
So you're asking him to serve extra time then?
It's 30 days and he's got credit for 8 already. That's my
All right.
understanding.
So,
We believe that will result in 7 extra days of jail, Your Honor.
all right, 7 extra days, that's what I've got. Thank you. All right. Anything else, Ms. Allen?
So the incident location, I already stated it was in and around the Georgia State area, but the victim specifically in this case, her name is Latasha Wright, and he's to have no contact with her.
Latasha Wright with a W?
Yes, ma'am.
All right, thank you. Mr. McLean, you've conferred with your client. Has he accepted these terms?
He has, Your Honor. He will stay off Georgia State University property.
All right, and do you stipulate to the factual basis, venue, and ID for this case?
We do.
All right, thank you. Mr. Irons, you've already been placed under oath. Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Not fully, but I do. I've been in custody longer, but if I have to serve a little bit more, I don't mind, Judge.
Well, I'll try to explain that to you. Have you understood and are you satisfied with your attorney at least?
Yes, Your Honor.
All right. Now, do you understand that you are addressing a plea offer? In other words, you're agreeing to plead guilty in exchange for a recommended sentence.
Yes, Your Honor, I do.
Okay, that part you do understand.
Yes, I do.
All right.
I was just
You've been in,
Oh, I'm sorry.
you've been in custody for 8 days now. And the prosecutor has offered that if you decide to plead guilty to battery and willful obstruction charges that allegedly occurred on October 13, 2022, somewhere on or about Georgia State University property. Do you understand that so far?
Yes, ma'am, I do.
Okay. The state is offering 12 months of probation, 12 months to serve 30 days, credit for time served 8 days. With the math that the sheriff uses, you will have 7 more days to serve at the Fulton County Jail. Do you follow me so far?
Yes, ma'am, I do.
And if once you've completed the 7 additional days, you will then be released and placed on probation, during which time you would need to complete 12 weeks of anger management classes at your expense, stay away from all Georgia State University property, and have no contact with Latasha Wright. These are the terms of the sentence that the state is offering. Is that something that you're still willing to move forward?
Yes, Your Honor, I am.
All right. If you decide to accept these terms, you will have to give up your constitutional right to go back to court, to have a trial in front of a judge or a jury, to be able to confront your accuser, examine witnesses, challenge the evidence presented by the state, present your own defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
I am, Your Honor.
How do you plead? To 1 count of willful obstruction of an officer and 1 count of battery.
Guilty, Your Honor.
Your sentence is 12 months to serve 30 days, credit for time served 8 days. Once you're on probation, you will complete 12 weeks of anger management classes, have no further contact with Latasha Wright, and stay away from all Georgia State University property. Thank you.
Thank you, Your Honor. I'll leave.
Yeah, you're done.
Position 6, Frederick.
All right. Will the host please let 4 North into the Zoom? Thank you. Repeat the case number again, position number?
It's position 6, Frederick.
6, okay. Willie Frederick is accused of battery in case number 22 CR 006-892Y from October 13, 2022. Mr. Frederick, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. This is going to be a negotiated plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Allen, what's the plea offer?
Sorry, Your Honor. I
That's all right.
apologize. What position is Mr. Franklin?
Position 6, Willie Frederick.
Frederick, that's my fault. Excuse me. One moment. So this is one charge of battery, Your Honor. The offer is a 12-month sentence with 30 days to serve, credit for 15 days he's already served and the balance probated, a 12-week anger management course, no further contact with the victim, Milton Colbert, and to stay away from the incident location.
140 Dolphin Drive? The Tiger apartment
1140, I
complex?
believe. It's apartment 12.
Okay. And is this in Atlanta?
Yes, I believe so. This is,
Okay. All right. Mr. McLean, are those the terms to which your clients accepted, and do you stipulate to the factual basis, venue, and ID?
Those are the terms and we do so stipulate, Your Honor.
All right. Mr. Frederick, have you consumed any medication or alcohol recently?
No, Your Honor.
And are you satisfied with the representation you've received from Mr. McLean?
Yes, but I do have a couple of concerns, if I may address it right now.
Sure.
Are they concerns that I can address myself through a visit to the jail this afternoon?
No, I'd like to proceed, but I was wondering, I don't know my financial situation once I get released. I was hoping I can get 4 months waived on my probation fee, and hopefully I'll be on non-reporting after I complete the anger management class. I just want to get that understanding.
All right. Well, Mr. McLean, I applaud your client. He's been listening to the other cases. So he's asking for 4-month probation fee waiver and non-reporting once he's completed the conditions. I'll agree to the 4-month fee waiver. Ms. Allen, do you have any objection to non-reporting?
no, Your Honor, as long as the 12-week anger management class is successfully completed
Understood.
and
Thank
the
you.
other terms are abided by.
All right. To answer your questions, Mr. Frederick, question number 1, yes, I'll agree to a fee waiver of probation fees only. And that means that you will actively report to probation every month, but you need not pay probation fees for the months of November, December, January, and February of 2023. Understood?
Thank you, Your Honor.
And if you complete the conditions of your sentence before the end of February 2023, then your probation will be non-reporting.
Thank you, Your Honor.
All right. But up until then, you need to actively report. Does that answer your questions?
Yes, Your Honor. Thank you.
All right. So getting back to your questions, is anyone forcing you or inducing you to take a plea today?
No, Your Honor.
And has it been explained to you that if you plead guilty to the charge today, you would have to give up your constitutional right to go back to court, to have a trial in front of a judge or a jury, to be able to confront your accuser and examine witnesses, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of battery?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other holds at the jail, you should be released within 24 hours. You will report to the probation office at 132 Mitchell Street in Atlanta, Georgia, next Thursday. Understood?
Yes, Your Honor.
All right, and while you're on probation, you will complete a 12-week anger management program at your expense, and you are to have no further contact with Milton Corbett. You're also to stay away from 140 Dolphin Drive in Southwest Atlanta. A specific apartment number. Do you live at that complex?
No.
So I want you to stay away from that entire apartment complex, not
Okay.
just any specific apartment.
One last concern, Your Honor. I do have property there. I was renting a room at that address. I believe they gave me a one-time courtesy to get my property. So I just want to make sure that's understood.
I will allow for one-time visit. You would need to report to that property with a police officer. You must have a police officer accompany you to the location, and you have to go directly to the leasing office or to the management office for two reasons. Number one, confirm that you do have a room there and that the room does contain your property. And number two, to see that it's still unoccupied so that the leasing agent can let you visit that room.
Okay.
And that visit cannot exceed 1 hour.
Okay. Thank you, Your Honor.
Thank you.
Your Honor, our understanding based on conversation with the victim is that this gentleman was staying with the victim for less than a 3-month period, that there are none of his belongings at the location any longer. He has no reason to return there.
Well, then he'll confirm that with the leasing agent. Allow him one-time visit to confirm that with like I said, he's not to go directly to the apartment. He's to go to the management or the leasing office.
With a police officer.
With a police officer, all
Thank
the way
you.
right up to the apartment, if he's allowed. Thank you. 4 North, who do we have?
Position number 10,
All
Hammond.
right. Position number 10, I have Mr. McLean's client, and that would be Antonio Hammonds. Are you Mr. Hammonds?
Yes, ma'am.
All right. Mr. Hammonds, my name is Judge Lal. We are addressing your case 22 CR 000078J, in which you are accused of battery, family violence, hindering a person from making an emergency phone call, and cruelty in the 3rd degree from January 4th, 2022. Mr. Hammonds, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Mr. McLean, I understand this is going to be an arraignment. Is that correct?
Correct.
All right. Mr. Hammonds and Mr. McLean, do you waive a reading of the accusation?
Yes.
All right. Mr. Hammonds, I just want to confirm one thing. You are here on a all right, looks like he's here on a bench warrant. His bond, I'm not sure if, I guess he made bond in this particular case, but with regards to an arraignment, Mr. Hammonds, I've read the 3 charges that have been brought against you. They are misdemeanor offenses. And upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, you will have a right to be assisted with counsel and be present during the course of the trial. The prosecutor, who is the Solicitor General's Office of Fulton County, they have the complete burden to prove the charges against you beyond a reasonable doubt. If they prevail, you could be convicted of 1 or more of these charges and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Not guilty.
Repeat.
Not guilty.
Your case has been arraigned and is going to be further noticed for trial. Thank you. That concludes your matter.
Okay, thank you.
All right. Courtroom 2, who do we have, please?
This is position 5, Dennis.
This is Javel Dennis, 22 CR 006-906D, accused of loitering and prowling and willful obstruction of an officer from October 13th, 2022. Mr. Dennis, you have been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath for purposes of this plea hearing? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Allen, what is the plea offer for these two charges?
Your Honor, the offer in this case is 12 months with 28 days to serve. The defendant will get credit for the 14 days he's served already. The balance is probated. He'll complete 20 hours of community service and stay away from the incident location. This is Lenox Road, 2865 Lenox Road. And then it is also, I think, agreed that he can be non-reporting after he completes the conditions.
All right, thank you. Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
He does accept the terms and we do so stipulate.
All right. Mr. Dennis, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea offer today?
No, ma'am.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not be able to sit in a courtroom, have the assistance of counsel, confront your accuser or examine witnesses, challenge the state's evidence, or present any defenses. And you would also give up the right to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of loitering and prowling and one count of willful obstruction of an officer?
Guilty.
Could you repeat that response?
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. This will be a concurrent sentence for both charges. The remainder of the time you will be on probation. You will report to probation next Thursday at 132 Mitchell Street. You'll be on active probation while you will have to complete 20 hours of voluntary community service and stay away from 2865 Lenox Road in Atlanta, Georgia. Once you've completed the 20 hours community service, your probation may be non-reporting. Thank you. Ms. Markelia Patterson, please mute the screen. My goodness, I don't know what she's doing. Will the host please mute Markelia Patterson and close her video? Markelia Patterson. Please mute the screen. Thank you. Okay. Mr. Jordan, can you mute Markelia Patterson, please? April, do you have co-host?
No, I'm not co-host.
Okay, thank you.
Ms. Grace is host.
All right, thank you.
It's
courtroom
done,
two?
Judge.
Oh, I see. Okay, thank you, Ms. Grace. I wasn't sure. Courtroom 2, who do we have?
Position 2, Cole.
Thank you. We have Akita Cole, accused of theft by taking from June 21st, 2020, in case number 21 CR 003720B. Mr. Cole, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a negotiated plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Allen, what's the recommendation for Mr. Cole?
Your Honor, the offer in this case, one charge of theft by taking is a 12-month sentence with 266 days to serve. He'll get credit for 133 days he's already served. The balance will be suspended and he's to stay away from the incident location. That's 2848 Main Street.
Okay, and that would be in East Point?
Hello?
I believe so.
All right, thank you.
I wanted to express the.
All right, Mr. Cole, did you have a question?
It says that on the
Yes,
report that I referred to him as,
I got a question about any holds do I have, or would I be released in 24 hours?
Okay, I'm going to stop you for a minute. Is someone else talking in that
Higher.
room?
Lower your voice.
his attorney had.
Okay.
Referred to him as Michael Cooper, which was correct.
We're gonna have to tell him to be quiet because we can hear his confidential communication.
You gotta, no, you gotta wait for that.
All right, Mr. Cole, did you have a question that you need to ask your attorney?
Yeah, do I have any holds, or would I be released in 24 hours?
But the,
I'll be at the jail this afternoon and can look up any holds that you possibly could have by the time I get to your visit.
I don't know whether he's got any other holds in other jurisdictions, but let me see right now. You have $1,000 bond on this particular charge, theft by taking. I don't know if you have a probation matter. Looks like you were continued on probation. I don't know if you have a probation hold. Back in 2019, you were continued on probation, but it looks like you may have a probation hold. All right. Okay. Courtroom 2, maybe unmute. So, Mr. Cole, would you like to proceed with the plea hearing, or would you like to wait until the probation holds resolved?
No, I like to continue.
All right. So, Mr. Akita Cole, your case number is 21 CR 003720B, accused of theft by taking on June 21st, 2020. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Cole, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you entering into this plea offer willingly and knowingly and voluntarily,
Yes,
even knowing that you may have a probation hold?
yes, ma'am.
All right. Are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to theft by taking, you would have to give up your constitutional right to go back to court and have a trial, to confront your accuser, examine witnesses, or challenge the state's case, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up some of these rights?
Yes,
How do you plead to one count of theft by taking?
guilty.
Your sentence is 12 months to serve 266 days, credit for time served 133 days. The remainder of the time is suspended. You are to stay away from 2848 Main Street in East Point, Georgia. And the sheriff's office will process your release. If the probation hold is determined to be lifted within the next 24 hours, then you should be released. Otherwise, you would have to wait until you have your probation hearing. Thank you.
Position 1, Carmichael.
Terrence Carmichael is accused of battery domestic violence, case number 22 CR 006890G from October 13, 2022. Mr. Carmichael, you have been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, this is going to be an arraignment and a bond hearing. Would you agree?
Yes.
All right. Do you waive a reading of the accusation?
Yes, we do.
Mr. Carmichael, you've been accused of battery domestic violence, and this is a misdemeanor offense. You are legally presumed innocent of this charge. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecution would have the burden to prove the charge against you beyond a reasonable doubt and to overcome your legal presumption of innocence. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right, thank you. This case has been arraigned and is going to be further notice for trial. Excuse me. Mr. Carmichael had his initial appearance on October 14th, 2022, at which time he received a $4,000 good bond by Judge Mincy with the conditions to stay away from, I think is Kenise Reed, and to stay away from Lyndhurst Drive. Do I have a pretrial officer, please?
Good morning, Judge.
Ms. Harrison, good morning. May I have Mr. Carmichael's priors, please?
6 cycles, last arrest January of this year, criminal trespass in Clayton County. No disposition listed on that arrest. Records indicate the defendant is currently on probation in Clayton County. Case number 22CR 04653, sentenced September of this year, 12 months probation. Nothing further to add.
Was that for the criminal trespass?
Yes.
Has he got any prior arrests or convictions for battery, domestic violence, or any kind of violence issue? No, thank you. All right, Mr.
He had a 2019 arrest for cruelty to children, but it was dismissed.
I see. All right, thank you. Mr. McLean?
Your Honor, he has a friend who has a home, and so that will be a stable address for him. It is out of state, but it is very stable. And he is a veteran. And due to his, as the court has heard the arrest record, we would ask the court to consider a signature bond. I do have a email address, which I can provide through chat or other means to the court and to pretrial release people about what his email address is. This is something he checks every day.
So
he also has a battery conviction out of Cobb in 2022.
Oh, okay. Now I understand the bond. All right. So battery conviction from 2022 in Cobb County. Was he on probation or anything?
It doesn't indicate, it only indicates that it was a conviction, but the sentence is not listed.
Okay, thank you. All right, anything else, Mr. McLean?
Nothing else, Your Honor.
Ms. Allen, or who is arguing for the state?
Your Honor, that's me.
Okay.
We would request that the bond remain the same. This gentleman's got a prior history of battery against a different victim. He is proposing at this point, I guess, to move out of state and leave the court with an email address. We don't believe that's a substantial change in circumstances at this point to warrant a change in a bond. This case involves a woman. He woke up, he's got 2 children with her. He woke her up, argued with her, and proceeded to grab her neck from behind, push her, punch her in the face, and scratch her. This was all witnessed by his own mother, who was present in the home as well.
All right.
We believe he's a danger to reoffend, a danger to flee, and a danger to intimidate. Thank you.
Thank you. All right. Mr. McLean, yeah, go ahead.
I should mention he does have a job available. He's quite employed. He's quite Amazon. He's quite employable. They're national, so he can work anywhere for them. And that employment, that employability, he and I discussed the airfares and the cost of being available for trial on quick notice at any time. And he is confident that he will be.
All right. He was convicted this year of criminal trespass in Clayton County. He received a battery conviction in Cobb County, and he's facing a brand new case in October 13 for battery domestic violence. And the only other option was to him to move out of state. I totally concur with the state's concerns that it sounds like Mr. Carmichael is not really seeking employment, but seeking flight. The bond shall remain the same at $4,000 with the same conditions being to remain as Judge Mincy has indicated. This case is going to be arraigned and further notice for trial. Thank you. Next case, courtroom 2, please.
You can go to 3 South, Judge.
All right. 3 South, may I have the position number of the case?
Position number 23, Sims.
Thank you. This is going to be Mr. Deshaun Kamar Sims, accused of battery from September 13, 2021, case number 21 CR 004-869Y. Mr. Sims, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Helen. Ms. Helen, I understand that your client wants to plead not guilty and also wants his bond reconsidered. Is that correct?
That is correct, Judge.
All right. Do you waive a reading of the accusation?
I do, Your Honor.
Thank you. Mr. Sims, you've been accused of 1 misdemeanor offense of battery. Upon your entry of a not guilty plea, the case will be scheduled for trial, at which time the state would have the burden to prove the charge against you beyond a reasonable doubt and to overcome your legal presumption of innocence. If the state prevails, you could be found guilty and be sentenced to up to a year in prison and or up to $1,000 fine. And given this information, how do you plead?
Not guilty.
Repeat the response, please.
Not guilty.
Did you say not guilty?
Yes.
This case is arraigned and further notice for trial. In this particular matter, arraigned and further notice, yeah. In this particular case, Mr. Sims received a signature bond on September 14th, 2021 of $2,000 signature bond through the jail. He failed to appear in court on August 10th, 2022. A bench warrant was issued and a cash bond was instituted. So, let me go ahead and find the status. Ms. Harrison, any priors on Mr. Sims?
He has 1 prior arrest out of Michigan. That was August of 2015, disorderly conduct, willful obstruction of law enforcement officer, criminal trespass.
All right.
And it was a conviction.
All right. Any other prior? So he's
No.
only got he's only got 2 cycles or
Correct.
3? Okay. He currently has a $3,000 cash bond only pursuant to the bench warrant. Ms. Helen?
Yes, Judge. I'm requesting a bond hearing for Mr. Sims today. He's 35 years old. As I think you may have heard a little bit, just you're hard to hear him. He has cerebral palsy and has had cerebral palsy since his teens, Judge. And so he's been 5 years in Georgia, but he is from Michigan, as you heard that other case. That case was in 2015. I didn't hear that it was a violent charges. That's because Mr. Sims is not a danger or a dangerous individual or violent offender, Judge. He's not a career time criminal. We are asking for this bond to be modified back to the original signature bond. If you would like to keep it in the same amount, that's fine, Judge, because when I spoke to Mr. Sims, he understood that he didn't get another case. He failed to appear. He tried to contact the clerk's office. He tried to get in contact with someone to say, hey, I have missed this court date. I want to try to see what the next court date is, Judge. And he's tried to do that. He also has issues with transportation, Judge. So he's tried to make these court dates. It was just a small incident where he did call to see what happened. Judge, we do have a permanent strong address for Mr. Sims, 1605 Peachtree Street, which I believe is updated in Odyssey. We will have no more failure to appears for Mr. Sims. This was specifically just an issue of him getting to the courthouse with all of the things that he was doing, Judge. And not only did he have this disability, which he's still trying to make these court dates with, Judge, he is employable. He was having an interview prior to being arrested, Judge, so he is employable. I don't believe he's a danger to the community. I don't believe he's a danger to this person, Judge, because he believes we're going to take this to a full jury trial because he believes he has a defense of self-defense, Judge. So yes, we are going to request that this bond be modified to $3,000, but in a signature bond, give Mr. Sims the opportunity to fight this case on the outside. And so far total, he spent 23 days inside of the Fulton County Jail with how dangerous it is with his disability, with his condition, Judge. So we are asking for that bond modification.
All right, thank you. Ms. Allen?
If I could hear from pretrial again about the 2 prior arrests and 1 conviction out of Michigan, because I believe I heard obstruction of police was one of those.
Ms. Harrison?
He has 1 arrest out of Michigan.
And what was the conviction for?
One moment.
I had disorderly conduct, so.
It was, it says assaulting or obstructing public officer.
Okay. Your Honor, this incident occurred when the defendant is alleged to have assaulted a nurse at the Atlanta Heart Associates location on Peachtree Street. Your recitation of the procedural posture is correct. He was originally granted a signature bond in this case. He failed to appear at plea and arraignment. He failed to appear at the jury trial, and his bond was forfeited. And so this should be an argument in front of Judge Eady, honestly, especially if the claim is that this gentleman tried to call the court and just wasn't able to get through to anybody. At this point, I think the facts and his history show that he is a danger to the community. And we believe this is an issue that should be reserved for the trial court, seeing as he's failed to appear multiple times in the life of this case. He's got a $3,000 cash bond. We believe the conditions should remain the same.
Multiple times. Yeah, I got a January 10th and August 10th. Okay. Bond is reduced to $1,000, a surety bond. No further contact with J. Favors. Stay away from the incident location. And the case is further notice for trial before Judge Eady. Ms. Helen, you might want to contact your counterpart to get this case back on the trial calendar since it already was.
Understood, Judge.
Thank you. And please submit the modified bond order to Ms. April Champion. Next case, please.
Position 24, Thomas.
Damon Timothy Thomas is accused of theft by taking a misdemeanor charge from October 10th, 2022 in accusation number 22 CR 006875Y. Mr. Thomas, you've been advised of your right to remain silent, and your attorney is going to be Ms. Helen. I have an arraignment and a bond hearing. Would that be correct, Ms. Helen?
That's correct, Judge.
All right. So do you waive for reading of the accusation?
I do, Your Honor.
Thank you. Mr. Thomas, you've been accused of theft by taking. Upon your entry of a not guilty plea, the case will be scheduled for trial, at which time the state would have the burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state does prevail, you could be convicted and face a penalty of up to $1,000 fine and or up to a year in prison. Given this information, how do you plead?
Not guilty. Not guilty.
Thank you, sir. Your case has been arraigned. With regards to your particular case, position number 24. Ms. Harrison, may we have his priors, please?
10 cycles with 1 arrest out of Michigan. Last arrest was September of this year, theft by shoplifting in Fulton County. That is an open case, 22 CP 212725. He was on pretrial. Pretrial did surrender that bond with this new arrest. Also,
This was a felony theft by shoplifting?
yes.
All right.
And he has an additional open case, 22 CP 213155, for possession of tools, theft by taking, willful obstruction, and possession, 2 counts of possession of tools.
Possession of what? I'm sorry?
Possession of a crime, 2 counts, loitering and prowling, 2 counts.
Okay,
And
I have possession of tools, willful obstruction, loitering and prowling.
yes, and possession of marijuana less than an ounce. That's an
Oh,
open
possession
case.
of marijuana. Okay, thank you. Okay, Miss Helen?
Yes, Judge. Today, from Mr. Thomas, for this theft by taking, we are requesting a bond hearing. We're requesting a bond modification. I believe it's a $2,000 surety. We're requesting for a $2,000 signature. If you feel like he's ineligible for that signature bond, we are asking for a bond reduction to no more than $1,000 for this theft by taking. When I spoke to Mr. Thomas, he does have strong family ties in Georgia. He has many uncles and cousins who live in the DeKalb County area. He does not have children, Judge, but however, he sustained a major injury in September of 2022, a car accident, and to which he almost had to learn how to walk again. He was in the trauma unit at Grady for a substantial amount of time, Judge. And so we are asking for that bond modification first to a signature, and if not that signature, a modification to no more than $1,000 surety, Judge.
All right. Miss Allen?
Your Honor, the state would object to any adjustment in this defendant's bond. You just heard from pretrial that he has 2 open felony cases that are similar in nature. Their offense dates are October the 11th of this year and September the 28th of this year. So obviously he wasn't injured too badly in that car accident in September. He is a risk to reoffend, commit other felonies, and a threat and a danger to people's property. This case, before the court today, the defendant snatched a scooter from a young woman. That scooter is valued, because we're here in misdemeanor court, at less than $1,500. I'm not sure why his bond should be less than that. We'd ask that it stay the same.
All right. Anything else, Miss Allen?
No, Your Honor.
I'm just looking at the charges brought against him. It looks like everything just accumulated in October. I think Mr. Thomas poses a higher likelihood to reoffend than we care for, and the $2,000 bond is adequate. We're going to maintain that same bond, stay away from Georgia Tech property, and have no contact with a Rajula Patti. Thank you. This case is arraigned and further notice for trial. Next case, please. I have 3 South. Who do I have?
Position number 7.
Thanks, Jordan. Navuth Kante Gaffney is accused of criminal trespass from October 12, 2022, case number 22 CR 006878E. Mr. Gaffney, you have a right to remain silent. Anything you say in open court about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Mr. Michael McLean. Mr. McLean, it looks like this is going to be an arraignment. Do you waive a reading of the accusation?
We do.
All right. Mr. Gaffney, you've been accused of 1 misdemeanor offense of criminal trespass. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state, that is the prosecution, would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for the convicted offense. Given this information, how do you plead to 1 count of criminal trespass?
I'm not guilty.
Right, sir? All right, Mr. Gaffney's case is position number 7. Ms. Harrison, may I have his priors, please?
Twenty-five cycles, last arrest, April of this year, disorderly conduct in Riverdale. No disposition listed on that arrest. Record does indicate an open probation for stalking. 19 CR 1717, sentenced April of 2019 with 12 years probation out of the cap.
All right, thank you. Miss Helen, he's got a $1,000 surety bond. He's got 45 cycles. He's got an open probation case. What am I modifying? I'm sorry, Mr. McLean, not Miss Helen, excuse me, Mr. McLean.
Oh, I was thinking you might have said Miss Allen. Your Honor, if he has a signature bond on this at this time, it would be moot, but otherwise he would ask for a signature bond on this. I'm not sure what the actual booking sheet is showing for him right now. Considering the nature of the offense and considering the state does feel that time served on suspended would be appropriate here if he were pleading, we don't believe he's a danger to the public in any kind of way. He just would make a promise to the court to come back for trial. He has the defense.
Okay. Miss Allen?
So just so I'm clear, the bond argument today is since the state has offered a time serve offer in this case, this defendant should get a signature bond instead of the surety bond that he's already got. He's got a failure to appear and has an active warrant out of DeKalb County, I believe on that 2019 stalking case that he's on felony probation for. And the modification, the reason for bond modification is the state's offer. Is that what we're saying?
Not just making the point that he's not a danger, and we think that y'all agree, and we're grateful that you agree with that proposition, but he's not a danger to the community, and he will come back considering the nature of the charge itself, is I think what is probably driving all parties' consideration of the case.
Your Honor,
Argument, Miss Allen?
we don't believe that there's a valid argument for a modification in this case. We believe this gentleman is a risk to reoffend and a risk to flee, and he currently has a hold on him for a failure to appear. So we believe he won't appear. Thank you.
Well, the allegations is criminal trespass, and the allegations state that he repeatedly refused to leave the model property after being expressly told to do so. So those are the allegations. It'll be very curious to know what the defenses are. The bond is set at $500. It is a surety bond. Mr. Gaffney, you have 45 cycles. You have an open warrant case. You have an open probation case. You do not qualify for the services of a signature bond.
All right, can I'd rather just plead guilty.
All right, you would need to confer with your attorney so that he can go over the documentation with you.
Yeah, but can I say something? Can I say something?
Mr. Gaffney,
if we're going to confer with an attorney, and if we're going to say something, why don't you just say it to me? I'll be glad to call you where you are, or the deputies can put you on a phone with me.
All right. So right now the offer is 12 months to serve 15 days, credit for 15 days. 3 South. Well, let me first ask, courtroom 2, who do we have in the courtroom?
We have Myers, 17, I believe.
17, that's Miss Helen's case. Okay. Miss Grace, if you could place Mr. McLean and 3 South in a breakout room, please.
Excuse me, Your Honor.
Okay, Judge.
Excuse, Your Honor, can I say something?
No. All right, 3 South and Mr. McLean, you're going to get a message on the screen to join a breakout room. And courtroom 2, that's position number 17. That's Mr. Jermaine Myers.
Correct.
Accusation number 22 CR 006891J. accused of simple battery at a public transit vehicle or station, disorderly, and 2 counts of disorderly conduct from October 13th, 2022. Mr. Myers, you've been advised of your right to remain, no, excuse me, I guess you may not. This is an announcement for everyone who may be in a courtroom right now, including South Annex. This is the state all-purpose calendar. If you are an accused charged with certain misdemeanor offenses, please remember that you have a right to remain silent. Anything you say about the facts of the case during the course of this recorded Zoom proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you from the public defense or conflict defense list. So with regards to Mr. Myers, his attorney is going to be Ms. Catrice Helen. And this is going to be an arraignment and a bond hearing too?
That's correct, Judge.
Okay, so Mr. Myers, and I'm sorry, Ms. Helen, do we need to read the accusation?
I do waive reading of the accusation, Judge.
Okay. Ms. Champion just notified me that Mr. Jermaine Myers was represented by Ms. Maureen McLeod. Conflict. Is the state taking over the case? I mean, the PDs?
I don't believe so, Judge. I don't have that information from Ms. McLeod. I didn't see an entry or any note entered. If that is the case, I would prefer to not cross-represent Mr. Myers if Ms. McLeod has already been assigned to that case and spoken to Mr. Myers.
It's a note and, obviously, about his case.
And I don't have notice from Ms. McLeod either that she's aware of that representation.
Yeah, Miss, where's the note that you see?
It's a flag at the bottom, conflict with,
Yeah. Yeah. All right. We're gonna have to reset this case to next Tuesday for Mr. Myers to address his case with the conflict counsel and to see whether he, and to see whether he wants to still proceed with an arraignment. Mr. Myers, back on October 14th, 2022, I guess about 2 weeks ago. Do you recall that your attorney was Maureen McLeod?
Yes.
Did you let Miss Helen know that you had spoken to a Maureen McLeod?
No.
All right. Miss McLeod is your attorney. The public defender's office is not permitted to represent you because they have conflicted out of the case. So that's why we appoint a conflict defense attorney to represent you, Maureen McLeod.
Could you repeat that?
The public defender's office is not permitted to represent you because there's a conflict of interest. Thereby, we appointed a conflict defense attorney to represent you when you were in court on October 14th. She's not with the public defender's office, she's with the conflict defense list. Do you understand?
Okay.
So I'm going to reset your case to November 1st, 9 a.m.
I need to get back to work.
Well, Mr. McLeod, I see that you already received a bond for $5,000. Good bond, which was.
Ma'am, I'm alone here in Atlanta. I don't have anyone to bond me out. I can only do a signature bond so I can go back to work, ma'am. I don't have.
Ms. Harrison, what is Mr. Myers Priors?
I really need this.
I need you to keep quiet now because your attorney is not present. Ms. Harrison, may I have the priors for Jermaine Myers?
Yes, Judge, one moment. 8 cycles, last arrest, March of 2014. for possession of marijuana less than an ounce in Camden County, Georgia. No disposition listed on that arrest. He has a 2003 carrying concealed weapon misdemeanor conviction out of Camden County, a first offender conviction for theft by taking. It was sealed in 2017 in Clayton County. And that's it, Judge.
All right. Okay, Mr. Myers, like I said, I cannot adjust your bond until I have your attorney present, your legal attorney. And that will be conflict defense. That's the bond that was set by the judge at initial appearance on October 14th. And if your attorney was present, I'll be glad to listen to your attorney. So given the nature of the case right now, we will address it next Tuesday, which is the earliest possible date I have at 9 a.m. before Judge Morrow. Thank you.
Okay. You got mine.
And please make a note that this, Miss Helen, I don't know what's the internal note taking at the Public Defender's Office, but this is a conflict case.
Yes, Judge. I see the note. It's kind of small in Odyssey. Normally it's under summary and hearings, but I'll just send an email to Miss McLeod.
Courtroom 2, who do we have?
This is position 3 Collins, but I did request, because he's for his hearing for that to show okay, here it is. We got it. We're good.
Okay. This is position 3. Is Mr. McLean still in the breakout room? Francois, Mr. McLean is still in the breakout room with Mr. Gaffney. Do you have positions 15 through the 27th?
The only person I have left is for the competency. I don't know if Derek Howard is available.
All right. Mr. Derek Howard, I saw him walking across the courtroom, so don't see him on Zoom. I'll put a pin on courtroom 2 right now. Just hold. South Annex, who do we have?
Position 20, Ms. Price.
All right, thank you. That would be Miss Helen's case. Sharika Price is case 20 CR 005887D. Miss Price was accused of theft by shoplifting from June 9th, 2019. Miss Price, you've been advised of your right to remain silent, and your attorney is Miss Helen. This is going to be a non-negotiated plea. So I'm going to first hear from the prosecution as to their plea offer and the reason why they're seeking a guilty plea entry. And then I will hear from the defense counsel as to the alternative recommendation to permit Miss Price to enter a nolo contendere plea. All right, Miss Allen?
Yes, Your Honor. So let's see, this offer was 12 months, looks like 131 days and credit for 131 days, balance suspended, and to stay away from the incident location. This is a accusation from 2020. She is currently in the Fulton County Jail because of a bench warrant that had been issued by Judge Edline. This was placed on 2 dormant statuses during the life of the case. The defendant failed to appear for a status conference in 2021 after being arraigned and given a bond, a signature bond. And previous to that, a bench warrant was issued in March of 2021. And it appears that there is an argument, I guess, that this could be a felony. When I look at the position for why this should or should not be a NOLO plea, there are 1, 2, 3, at least 4 prior convictions for theft by taking. And I believe that that's why the state's position is here, what it is.
Taking?
You're talking about theft by shoplifting?
Theft by shoplifting, theft by shoplifting, excuse me.
All right, I have a December 6, 2018.
Mhm.
I have a December 20th, 2018. I have a June 26, 2019. And these are all convictions for theft by shoplifting. Ms. Harrison, do you have any further convictions for theft by shoplifting?
I don't, Judge.
So I see 3 out of Fulton County and 1 out of Clayton County.
I see, okay. And do you have a disposition date for the Clayton County?
I see
2018. 2018.
2018 as well. Okay, thank you. All right, Ms. Helen, why should I grant your client a nolo contendere?
Judge, I just wanted her to be able to use that NOLO. Again, I spoke to Ms. Price. This is not going to happen again. As far as the theft by shoplifting, she has a much stable address with her mother, a much stable living arrangement. She understands to stay away from that Walmart, Judge. And so basically we're asking for her history, her criminal history. If she has not been able to use the NOLO in the last 5 years, it is this court's discretion to rule whether or not you will allow her to do so. And so
I'm going to refuse the NOLO. I'm just looking at her criminal charges, both superior and state court. And in all good conscience, I cannot accept it. So if Ms. Price would like to plead guilty to theft by shoplifting, understanding that any subsequent arrests for theft by shoplifting will automatically be determined to be a felony charge. Ms. Price, would you like to continue with this plea hearing or would you like to have a trial?
I'd like to continue.
Okay. Ms. Helen, are you comfortable to proceed with this hearing?
I am, Judge.
Right. And do you stipulate to the factual basis, venue, and ID?
I do, Judge.
Ms. Price, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Price, as we have already heard, your criminal history record and the plea offer by the state. You are accused of theft by shoplifting from June 9th, 2019. Have you consumed any medication or alcohol recently?
Medication.
Have you consumed any medication or alcohol recently?
Medication.
And after consuming the medication, are you still able to understand the proceedings?
Yes.
Are you able to understand your attorney?
Yes.
And are you satisfied with your attorney?
Yes.
Do you understand that you are accused of theft by shoplifting?
Yes.
And if you plead guilty to this charge today, any subsequent arrest will automatically be a felony charge by operation of law. That means automatically. It doesn't matter whether it's a stick of gum or a can of Coke.
Yes.
And are you still willing to proceed with this plea hearing voluntarily?
Yes.
Okay. Do you understand that by pleading guilty, you would give up your right to a trial? You will not be able to go back to court to have the assistance of counsel, to confront your accuser, challenge the state's case, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared
Yes.
to give up these rights?
Yes.
How do you plead to one count of theft by shoplifting from June 9th, 2019?
Could you repeat that again? I didn't hear you.
How do you plead to one count of theft by shoplifting from June 9th, 2019?
How do I plead? What did it, I don't know what that means.
They're asking you if you want to plead guilty or not guilty.
Guilty. I'm guilty. They got the stuff back though.
Ms. Price, is this the first time you're having a plea hearing?
No.
All right.
Guilty.
All right. I just want to be sure you understand what I mean when I say, how are you pleading to a charge?
Okay.
Do you understand the question?
Yes, ma'am.
So I'm going to repeat again. How do you plead to one count of theft by shoplifting?
Guilty.
Your sentence is 12 months to serve 131 days, credit for time served 131 days, balance suspended. You have to stay away from the incident location. Was that a Walmart?
Yes, ma'am.
You are to stay away from all Walmart shops. You're not to enter a single one.
Yes, ma'am.
They have about 500,000 on this entire planet. You cannot visit any of them. Do you
Yes,
understand?
ma'am. Yes, ma'am.
Thank you.
Thank you. Yeah. Okay.
You made her day, Miss Helen. All right. Courtroom 2, who do we have, please? Was that Mr. I'm sorry. I have position 7, Mr. Gaffney at 3 South. And was that Mr. Timothy Collins?
Yes, Collins, number 3.
Number 3, okay. Mr. Timothy Collins from position number 3 is accused of theft by receiving stolen property and theft by shoplifting from October 14th, 2022. Accusation number 22 CR 006902C. Mr. Collins, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, are we still proceeding with a negotiated plea?
Yes, Your Honor.
Mr. Collins, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Please raise your right hand to accept the oath. Mr. Collins, hello? Can you hear me?
Yes,
Yeah.
Are you Timothy Collins?
Judge Law.
Yeah.
He has a hearing aid, so he's reading the transcript.
I see. Okay. Mr. Collins, please raise your right hand to take your oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Just to make sure you understand, you can put your hand down.
Oh.
You have a right to remain silent. Anything you say, your statements can and will be used against you. Do you understand, sir? You have a right to an attorney. If you cannot afford one, Mr. McLean will be representing you. Do you understand?
Okay.
I understand that you want to plead guilty to theft by receiving stolen property and theft by shoplifting in exchange for a recommended sentence. Is that correct?
Yeah.
All right. The prosecutor is going to speak now. Please pay attention. Ms. Allen?
Yes, Your Honor. So there are 2 charges in this case, theft by receiving and theft by shoplifting. The offer is 12 months with 28 days to serve. Mr. Collins will get credit for the 14 days he's already served, and the balance of that sentence will be on probation. He's to complete a theft class, do 30 hours of community service, and stay away from the incident location. This is the corner market at 3332 Colville, Colville Avenue in Hateville.
Mr. McLean, are those the terms to which your client has agreed? And do you stipulate to the factual basis, venue, and ID?
They are, and we do. I do need to point out that the theft by receiving is of the alcoholic beverages and laundry detergent, and the theft by shoplifting is charged as party to a crime with somebody else of the same item.
Understood? Is your client still willing to proceed?
Yes, Your Honor. I think there would be a merger in that. in that matter.
I don't see it, but maybe the state can correct me. Are you merging the theft by shoplifting to the theft by receiving?
That is not what's contemplated in the notes I was given.
Mr. McLean, I don't see the merger for two entirely separate offenses. Was it party to a crime to separate items?
The laundry detergent and the alcoholic beverage was taken by another person, and he's said to have assisted in that matter. I think that is why the theory is that he's a party to a crime, and the same items are the subject of the receiving. So how can you steal something one way and steal something another way if they are the same item?
All right. I was under the impression it was completely separate items. Okay. So Ms. Allen, what's the state's position?
One moment, I'm reviewing. Seems like if there was an issue, this should have been spoken about before, but give me one moment. This incident was caught on surveillance. These individuals were identified through previous encounters with the same workers at the corner market. Female co-defendant was observed on surveillance, shoplifting alcoholic beverages, laundry detergent, and coffee, which she handed to the defendant here in front of the court, Mr. Collins. So she passed off these items. He took those items that she passed off to them. He is acting as a lookout on surveillance. Mr. Butler is then observed, or no, I'm sorry. Mr. Collins then walks off with a bag that he receives from Mrs. Butler and puts it in a trash can. That bag was later taken and identified with the stolen items inside. So we would argue there are different elements for theft by receiving and theft by shoplifting, and that this is not a merger. It's just artfully charged.
Anything else, Mr. McLean?
No, Your Honor.
All right, I'm going to deem this as two separate charges. Does your client still want to proceed?
He does.
Mr. Collins, you have heard the factual basis indicated by the prosecutor. Do you still want to continue with a guilty plea to theft by receiving stolen property and theft by shoplifting?
Yeah,
I'm sorry, repeat your response.
yeah,
Okay. Mr. McLean, I'm sorry if I'm being repetitive. Do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Collins, have you consumed any alcohol or medication recently?
no,
Have you understood the proceedings so far?
yeah,
Are you satisfied with your attorney?
yeah,
Is anyone forcing you to take a plea today?
no,
All right, just one second. Bianca Pache, please mute your screen. Thank you. I apologize. Mr. Collins, is anyone forcing you to take a plea today?
no,
If you decide to enter a guilty plea to these charges, you would have to give up your right to a trial, to go back to court and confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yeah,
How do you plead to one count of theft by receiving stolen property?
I plead guilty.
How do you plead to one count of theft by shoplifting?
I plead, guilty on both, I guess.
I don't understand. How do you plead to theft by shoplifting?
I plead guilty.
So you're pleading guilty to both charges. Would that be correct?
Yeah,
Your sentence for both charges are concurrent. It's 12 months to serve 28 days, credit for time served 14 days. If you
Okay.
have no other holds, you will be released within 24 hours. You must report to probation next Thursday at
Okay.
1:30.
thank you.
You have to report to probation next Thursday at 132 Mitchell Street in downtown Atlanta.
He wrote it down for me. I got it on paper.
While you're on probation, you are to complete an anti-theft class. You are to complete 30 hours of voluntary community service,
Okay.
and you have to stay
Why I gonna do that at?
because that is the plea offer to which you accepted through your attorney.
Okay.
You have to complete the 30 hours of voluntary community service. And
Okay,
you have to,
okay.
and you have to stay 200 yards away from the corner market at 3332 Colville Street in Hateville, Georgia.
I got you.
If you return to that market, you will be arrested again.
Okay.
I will waive your probation fees for now until the end of February 2023. You must report every month. Once a month,
Okay.
starting next Thursday.
Okay.
Thank you.
Thank you too.
Position, was Mr. Gaffney, and was it 7? Yeah. All right, Mr. Gaffney is at 3 South. Mr. McLean, you've conferred with your client. How would you like to proceed?
As he indicated, he does want to switch over to a guilty plea, Your Honor.
All right, with this, all right, so I'm assuming that you've communicated the same terms that were listed on the calendar.
Time served as the jail portion, balance suspended, stay away from this MARTA station during the pendency of the suspension, and also simply comply with all MARTA suspensions. And we discussed the distinction between this case and complying with MARTA suspensions in general.
I'm sorry, Mr. McLean, I'm a little puzzled. He would need to stay away from all MARTA property while there are any active MARTA suspensions against him. So if there is a start date and an end date, he cannot return to MARTA until after the end date with regards to any and all suspensions against him. So there is no distinction.
I agree with the court that if there is a MARTA suspension in effect now, he would comply with the end date. I explained to him that whenever you plead guilty to this, generally speaking, you're forbidden to go to that station. However, if there is a
No. Not any particular station. All of MARTA. No trains, no buses.
Excuse me, Your Honor, may I speak?
Quickly. Mr. Gaffney, if you want to plead guilty today, you would need to stay away from all MARTA property in accordance with any active suspension.
Yes, ma'am, may I speak? Your Honor.
Quickly, tell me what you want to say.
All right, I've been catching MARTA ever since I've been living here in Georgia. That's my means of getting from point A to point B. Like, how it is, like, first of all, all this happened because I was charging my phone. I left Model Station. I left at 9:07.
Mr. Gaffney, I am not going to allow you to return to MARTA if there's any active suspension against you.
I thought you said just 5 Point Station.
No, I never said that.
But that's where the incident took place at.
That's
5
what the incident said. You were kicked out of 5 Point MARTA Station. So I'm going to reset this case to
No.
choose.
No, ma'am. I plead guilty, forgive. No.
Yep.
I'm ready to plead.
He just wants to get out tonight, Your Honor. Let's, he will comply with, all MARTA. And the end date, somebody will tell him.
Nobody will tell him. He will need to contact the Lindbergh MARTA officers and find out what are the suspensions against him. At some point, we all got to put on our big boy britches and do it ourselves.
I already
Understood,
know
Mr. Gaffney?
I know when the end date is. I got it on my paperwork.
Very good.
All right. Mr. Gaffney's already been advised of his right to remain silent and his right to counsel. Ms. Allen, do you want to articulate the state's plea offer?
Sure, Your Honor. This is a 12 months to serve 15 days, credit for 15 days he's already served, to stay away from the incident location, that's MARTA 5 Points, and to comply with all active MARTA suspensions wherever and however long those may be.
All right. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We certainly do.
Thank you. Mr. Gaffney, have you consumed any medication or alcohol recently?
Medication.
And has that impaired your ability to understand the proceedings?
No, ma'am.
Have you understood your attorney and are you satisfied with this representation?
Yes.
And if you decide to plead guilty to criminal trespass at MARTA, you would have to give up your constitutional right to go back to court, to have a trial, to confront your accuser and examine witnesses, as well as to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes.
I'm not going to accept the plea offer if you're just guessing about it. So
And I said yes.
are you prepared to waive these rights?
Yes, ma'am.
And how, and are you entering this plea offer willingly, knowingly, and voluntarily?
Yes.
How do you plead to 1 count of criminal trespass at MARTA?
Yes.
Your sentence is 12 months to serve 15 days, credit for time served, 15 days. The balance is suspended. You are to stay away from all MARTA property in accordance with any active suspension. So if there is a start date, you can only start using MARTA after the suspension date is over. Understood? Your responsibility to contact MARTA headquarters and to ascertain which suspensions, if any, are pending against you.
Well, it says something. I got the paperwork. I think it say 10/26/22 or 11/26/22. That's like between now and this month. So like when that suspension day is over, I'm allowed to return to the station.
That's right. But you need to first confirm when those suspensions are. I do not know. If you're telling me it's that date, that's up to you. But you are going to be the one responsible for contacting the MARTA officers to ascertain your suspension dates. Understood?
Yeah, they put it on my paperwork. I got it in my property.
Thank you. That concludes this case. Courtroom 2, who do we have, please?
We have position number 7, but I've been told that he's with Derek Howard.
No, that would be incorrect. Position 7 was just addressed, Mr. Gaffney. Oh, that's on another calendar. What's his name, please?
Boyce.
All right. I will return to him shortly. Who's the other? Have I addressed everybody else in courtroom 2?
Yes, we have.
Okay, I will return to courtroom 2 very shortly. South Annex, who do we have, please?
This is the competency calendar for Mr. Derek Howard. Position 14, Ms. Collins.
Okay. Anybody else from the SAP calendar at South Annex?
No, Your Honor, that's it.
Okay,
I have someone on 3 South, Ms. Kelly's client, Mr. Maddox.
okay, South Annex, I'll return to the
Yes.
competency matter in a few moments. 3 South, I can
Hello?
barely hear you. Ms. Patterson,
Hello?
please mute your screen.
Position number 16, Maddox.
Position 16, thank you. All right, this is Norman Maddox on the SAP calendar, accused of simple battery domestic violence. Mr. Maddox, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. You're accused of simple battery domestic violence from May 22nd, 2021. This is going to be an arraignment and a bond hearing. Is that correct, Ms. Helen?
That's correct, Judge.
And do you waive a reading of the accusation?
I do, Judge.
Ms. Maddox, you've been accused of 1 misdemeanor offense of simple battery domestic violence. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Thank you. Mr. Maddox, just 1 second, was initially addressed on May 26, 2021. He received a signature bond through the jail in the amount of $5,000 from Judge Morrow to stay away from Shauna Smith. Subsequent to that, he failed to appear. He waived his arraignment on August 30th, 2021. And then he failed to appear for trial on July 25th, 2022. An arrest warrant was issued and his bond was forfeited. All right, Ms. Helen, what would you like to tell me?
Yes, Judge, this is a bond hearing today for Mr. Maddox, who's 57 years old. Judge, he has a host of medical disabilities. He has a doctor's appointment as soon as November 10th for a heart stent that he has. He has heart seizures, high blood pressures. He's on 3 major type of medications at the jail. He does suffer from an ailment that could cause him to stop breathing at any moment, Judge. So we are asking for this bond modification. He does not have any contact with the alleged accuser. He understands to stay away. That's fine, Judge, but we're asking for a bond modification in the same amount back to the original amount, the signature bond. I do see that he had a failure to appear in July 25th of this year, Judge, but when I spoke to him, he was not aware of missing that court date. He was not aware of even having notice for that court date. I believe the address of a 6207 Charleston Place is not correct, Judge. And with the host of disabilities he has, he wasn't able to update that information with the court, Judge. And so, Judge, we're asking for another opportunity for Mr. Maddox to be able to fight this case on the outside, and we are asking for that bond modification.
Hi, this is Ms. Brown next.
I'm sorry, Mr. Walker, could you mute the screen, please? Thank you. Sorry about that, Ms. Helen.
I'm so sorry, Judge.
Thank you, Judge. And so, yes, we are asking for that bond modification today for Mr. Maddox.
So
He
a
does
couple of tail ends, I'm not certain. The Charleston Place, Atlanta, Georgia is not the correct address, and that's the address that we received when he was at first appearance last year. Has it changed? Was it incorrect at that time? What are we talking about?
So when I spoke to him, Judge, and I just want to make sure this is clear, he suffers from a disability. He wasn't even able to give me the address. He was able to give me phone numbers to other individuals of his family members, but he could not recall the specific address. But he could tell me that was not the correct address.
All right. Is the disability stemming from a physical heart condition or is it a TBD situation?
It's a physical heart condition, Judge. There's an actual stent inside of his heart. So he has seizures.
So how is that impairing his ability to know his address or his cognitive memories?
I'm not sure, Judge, but he was not able to give me that information. And so with that kind of consequence, with those kind of disabilities, Judge, I just want to give him as much support as possible. He was able to give me 2 family members' phone numbers for to contact them, Judge, but he was not able to give me an address.
Then what assurance do I have that he's able to remember the next court date?
Judge, once I get that information, I will be able to add that to the probation contact list. I tried to reach out to those other 2 family members on the phone number. They did not answer, but I wanted to try diligently to contact them today to get the permanent phone, or excuse me, phone numbers, additional phone numbers, and a permanent address.
Miss Helen, even if I were to accept your argument, I still am not going to release him on a signature bond until I have certainty that we know who is going to take care of him if he has memory or cognitive issues, that he's going to be released to a identifiable person, and that there is some certainty that he will return to court. What you're telling me are what-if situations.
I do hear you, Judge. If we could have an opportunity to have this reset to next Thursday, maybe those family members will be able to answer the phone and I can get that permanent address for Mr. Maddox.
It's going to be reset to November 3rd, just on the issue of bond. Unless you get a faster date before Judge Edie. Thank you.
Understood, Judge.
This is arraigned and further notice for trial. Thank you.
Thank you, Judge.
Is there anyone else in 3 South that's on the SAP calendar?
No, ma'am. I have to go to 3 North.
Somewhere north. Okay. All right. Miss Helen, have we addressed all your clients on the SAP calendar?
We have not, Judge. Mr. Wabibi, positions 25 and 26 has not arrived. We have not addressed Mr.
They are on 3 North. I'm en route to 3 North now.
Okay.
Okay. All right. Mr. Walker and Mr. Derek Howard. I see Ms. Burgess is present. Folks, you are here in the courtroom. What cases are y'all here for?
Judge, she was on an original calendar with you on the 6th. But she had an evaluation done, competency evaluation. It hadn't come in yet, so.
All right, it's going to be
It was told to come back. And I think it was emailed down here. So,
Got the evaluation came back.
all right. We generally don't hold those cases in open, so as soon as I mute the screen, we can address your case. All right? Thank you. And yes, ma'am, are you here?
Derek Howard is representing me. I was told to come back here for a competency hearing.
Okay, again, we're not going to make any announcements, okay, until Mr. Howard's ready. Okay, Miss Helen, Mr. McLean, do you have any way of reaching Mr. Derek Howard? Okay.
I can try him, Your Honor.
Oh, there he is. It is
I am
magic.
Judge.
Okay. Okay, I'm going to go into a breakout room to address the competency matters. And the jail, we are still waiting on. Mr. McLean, have we addressed all your cases on SAP?
We have not. I don't think I've talked to Mr. Jacobs, who is number 13.
Okay, so you are waiting on position 13, Jacobs, and Miss Helen is waiting on position 25 and 26, Wabibi. I was waiting to say that name.
I think we also have position 8, position 9.
Anyone else?
Let's see.
Position 4, I think.
Position 4, I think that was one where I was requesting a breakout room to discuss an issue with the court and state.
De La Rosa, okay. Miss Grace, if you could place me and Mr. Ian Walker, Mr. Derek Howard, Kia Burgess, Mr. McLean into a breakout room, please.
Okay, Judge.
And the courtrooms with individuals on the competency calendar, we will get back to you shortly after we go over the competency matters because of HIPAA confidentiality issues. Hello?
Ms. Helen,
Yes.
okay, I'm holding with Della Rosa and he's getting impatient, so somebody needs to do something, because he's not gonna keep waiting.
Which position is that?
Della Rosa, position number 4.
Okay, is that for Mr. McLean? Okay, we're still waiting for the judge to come back.
How much? Okay. 1177.
My email is.
McLean.
TDA1407@gmail.com.
Hello,
Do you need to talk to Antonio Jacobs?
Mr. Jacobs, yes.
Okay, your cell phone number is 770, right?
770-891-4755.
All right, pick up.
My wife has the phone.
I don't know what Taco Bell is.
All right, courtroom 2, you had a gentleman or a couple of gentlemen from the competency calendar. Could you tell me their name again?
Number 7.
Number 7?
Boys.
Okay, number 7 on the competency calendar.
No. Okay, you're on the phone. Somebody else.
All right, Mr. Alan Boyce, is that correct?
Correct.
All right, Mr. Boyce, your attorney Derek Howard will be speaking to you shortly. But basically, we're going to reset your case to November 3rd. And where your attorney will discuss to ascertain a plan to move forward with your case. Understood?
Understood.
Okay, that's all I have to report. We'll see you on November 3rd. Thank you. Are there any other competency cases in courtroom 2?
No, that was all.
All right. Do you have position 8 and 9 Green or Jacoby, position 13?
Well, I have position, 4, De La Rosa right here, then I go grab one of those guys, cause I'm bringing them one at a time.
Okay. So that was Fulton, and you said you had Mr. De La Rosa?
Yes.
All right. Mr. Howard, do you just want to give me the? We didn't address this.
Which one, Judge?
Angelo De La Rosa.
Who would that be, Judge? He's not on the competency calendar.
Oh, he's not. Okay. No, he's Mr. McLean's case. He's Mr. McLean's case. Sorry. We will be with Mr. De La Rosa very shortly. South Annex, I think it's empty now. Deputy Milton, did you remove the competency matters from there? Okay, Deputy Milton's not in that. Okay, so I don't believe there are any other competency matters to address. I have a Markelia Patterson. Miss Patterson, what matter are you here for, or who are you here for?
Yes, ma'am. It was supposed to be a simple battery.
Are you a defendant, or are you a victim?
On here, her name is Shaniqua.
Are you a defendant, or are you the victim?
I am the defendant.
Okay. Ms. Patterson, if you want to put your case number in the chat. If you look at
I
the
don't know how
chat
to do
feature.
this.
Okay, what's your case number?
I don't know what's going on with this sound.
That's the victim.
Ms. Walker, please
that they
mute.
said.
Okay, what's your case number, Ms. Patterson?
I don't even know the case. They didn't give me anything.
My God, looks good. Sign. I'm sure you get the first print TV off the line.
Ms. Grace, could you please mute Shaniqua Walker?
Without any.
Hang on, give me the, hang on. Will the host, Ms. Grace, please mute Shaniqua Walker?
Well done, Mogul Man.
Thank you. What was the case number, Ms. Abe Champagne?
It's 22 CR 006897A.
Okay. And when did she make bond?
She made released on the 15th of October.
All right, Ms. Patterson, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney. You were represented by the Public Defender's Office. Have you spoken to them since then? Is she with us now, or is she gone?
She was breathing on the looks like.
Okay, so we're gonna move on that. Okay,
Judge, from excuse me for interrupting, Judge, but from what I can tell, it appears she had first appearance on the 19th, and it was reset to SAP, and she obviously bonded out.
yeah. I just need to make sure that she has an attorney and that she understands that her case has been further noticed for trial.
Okay. Yeah.
And the alleged victim is also on the Zoom, so if she shows up, she shows up. All right, for Fulton, we have Mr. Fulton. We have Angelo De La Rosa, if you want to unmute the screen. All right. Are you Angelo De La Rosa?
Yes, ma'am.
And your case number is 22 CR 006666F. Mr. De La Rosa, you're accused of criminal trespass from October 3rd, 2022. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. Mr. Michael McLean is not on the Zoom. Mr. McLean, are you on the Zoom? All right. Mr. De La Rosa, you have not had a chance to speak to your attorney, Mr. Michael McLean. Ms. Helen, do you know where Mr. McLean is?
I do not, Judge, but I'll give him a call.
Talk to him yesterday.
You spoke to him yesterday?
Yes, ma'am.
I'll call him, Judge.
All right. All right, please hold, Mr. De La Rosa. I need your attorney on the screen. Ms. Grace, if we can mute Fulton, the Fulton panel, please. Courtroom 2, who do we have?
We have 13, position 13.
And that would be Mr. McLean's client as well. We have 4, 8, and 9 in position 13, Jacobs. Is position 25 and 20, will BB available?
And then Judge, we also have the DV bench warrant client present as well. She was supposed to be here at 11 a.m. She's been here for the last hour, so she's ready.
Okay, yeah, we're going to get to that, but I need to make sure all the jail cases have been addressed. You were waiting on Mr. Wabibi.
Mr. Wabidi will be picked, I will get him once I take him back. I can't bring 2 people off that floor at the same time.
Well, I don't know where Mr. McLean is, so I guess.
Judge, Mr. McLean indicated he was put in a breakout room and he was trying to, so if they could just bring him out of the breakout room.
Oh, he's in a breakout room?
Come out, but he says he was inadvertently in the breakout. Yeah, he said inadvertently.
There he
in
is.
the breakout.
Okay.
Here he comes.
Excellent. Thank you. Mr. McLean, if you could unmute, please.
Right, I thought the breakout room was for either number 4 or number 8, 9, but apparently not.
All right, so have you had a chance to speak to Mr. De La Rosa?
Not today, but I spoke to him yesterday and I spoke to him about a week or 2 ago.
And how would we like to proceed with this case?
That was the case in which I wanted to speak to the court in the state in a breakout room.
All right. We're going to hold on that. South Annex, who do you have?
I have Ms. Collins, position 14 on the composite calendar.
Okay, position 14. Thank you. Do you have any other cases at South Annex?
No, Your Honor, she's my last one.
Okay. Ms. Collins, your attorney, Derek Howard, is going to send a transportation order to the court for you to be transported to the Nicholas house, and you would need to comply with the conditions of that bond order. All right. Mr. Howard, can you provide a guesstimate of the date of release?
The next Wednesday would be the 2nd, I believe, Judge. Yes.
Okay, so you will be released, picked up, and transported to Nicholas House on November 2nd, 2022. Okay?
Okay.
All right, thank you. That concludes the case. Thank you, Deputy Milton. Sorry.
Thank you. No problem. Bye-bye.
Ms. Patterson, your case number, if you want to get a pen and paper and write this down, is 22 C as in cat, R as in Robert, 006-897A. You were
What is it?
arrested. Listen very carefully. 22 C as in cat, R as in Robert, 006-897A. You were arrested on and seen before the court on October 14th, 2022. A bond order was issued by Judge Mincy. You received a $1,500 good bond by Judge Mincy on October 14th of this year. You are required to have no further contact with Seanricua Walker, who is on the Zoom. You are to stay away from 2282 Ivy Dale Drive in Southwest Atlanta. And you were permitted one-time visit to that location to retrieve your belongings and your children. But after that visit, you have to update the court with your new address, which means that you have to come down to 160 Prior Street on the first floor and update your new address in writing. Do you understand? All right. Moving on, we have Mr. McLean. We have position courtroom 2. Who do we have in courtroom 2, please?
Jacobs,
Jacobs, position 13. Excellent. Okay. And with regards to Mr. Jacobs, did you need a breakout session as well?
no, Your Honor, we spoke. Mr. Jacobs here was in a state prison during the date in question. Some people who are in state prison drive state prison trucks for construction or whatever, but on March 21st, 2017, he wasn't driving a truck for anybody. He was in the Department of Corrections.
All right. And so Mr. Jacobs, your case number is 17 CR 024137G. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. So this was traffic citations from March 21st, 2017.
Right. I'll research that. And if he was in the State Department of Corrections during that month, that date, then I would like to present that to the state so we can see if this may be some mistake as to identity.
You mean he wasn't driving or somebody else was driving?
No, I mean, he has no idea what this is. Somebody may have used his name. He was in a prison.
All right. So are we resetting the case?
Hey, excuse me.
As soon as possible. Is anything else holding him?
And if not, then we could go with outside.
Excuse me.
I could go to Odyssey and see if anything else is holding him.
I am looking at his jailings and driving looks like it's this one. He's got yeah, he's got other matters holding him.
Okay. Tuesday or Thursday would be, if he's going to be held through Tuesday or Thursday, then it could wait till then.
Yeah. He's got a bond in excess of 74,000 presently. All right. Yes, Mr. Jacobs, would you like an opportunity to speak to your attorney in private so that we can address your case next Thursday on November 2nd?
Yes, ma'am. I want to speak to him in private right quick.
You have a right.
I'll come to the jail.
Now I want to. It's going to be quick. Can we go to a break room?
You have the right to remain silent. Anything you say in open court, your statements can and will be used against you. I don't go into a break room just so that you could exercise your right to remain silent. If you want to say something to the court, you would have to voluntarily waive your right to remain silent, or you can wait until you have an opportunity to speak to your attorney.
All right, that's cool.
Next court date is November 2nd, 3rd, November 3rd on Mr. Jacobs. Thank you.
Thank you. Thank you.
Mr. McLean, so the only other position is 8 and 9, Mr. Green. So,
right,
so let's go to a breakout room with just Mr. McLean and Ms. Allen.
Okay, Judge.
Do I just join the breakout room? No, I didn't put in there. Miss Grace, go ahead and put Miss Allen and Mr. McLean in the breakout room. I just want to address Miss Patterson. Miss Patterson? Miss Patterson? Where is she? Is she? Can you hear me?
Yes, ma'am.
They're
Ms.
in the
Patterson,
breakout
can
room,
you hear
Judge.
me? Ms. Patterson,
Yes,
can
I
you
can
hear
hear
me?
you.
Okay, do not start your video
Yes,
because you
yes.
have Wi-Fi issues. Your case is going to be reset for trial, so make sure you contact the public defender's office to see that they can continue to represent you. You need to come down to 160 Prior Street
Go to
on the
trial.
first
I never
floor.
said anything about. I never said anything about trial. I don't want to go to trial. I'm not guilty of it, but I'm not. I don't want to go to trial.
All right.
Case says this case.
Ms. Patterson, I'm going to reset your case to November 3rd at 11 a.m. And I want you to come down to the courtroom in 160 Prior Street, courtroom G33. And if you speak to me like that again, I'll make sure the Marshal's Department is available right by your side. Do you understand?
No, ma'am. I didn't mean to talk to you any kind of. I'm
Okay.
not
Now,
doing that, ma'am.
now
Just
I'm going to give you some instructions. You do not interrupt. Do you understand?
keep disconnecting me.
That is your own Wi-Fi. I don't have a problem. Your case is reset to November 3rd at 11 a.m. for you to appear in person in courtroom G33 so you can get further instructions on what to do. Thank you. All right, Ms. Grace, you can put me in a breakout, please.
Judge, who would you like to be in the breakout room with? You're on mute.
Sorry, Mr. McLean and Ms. Allen.
Okay.
Fulton, please mute your screen. All right. We are making progress here. So, April, did you get the thing about Miss Patterson? The case is set for 11 o'clock. Okay. Mr. McLean, and let's address Mr. Angelo Della Rosa.
Yes, Your Honor, I would like to put that onto the competency calendar and talk with people in my office about the appropriate paperwork to file in case an evaluation is not already done.
Okay. Mr. Della Rosa, your case is going to be rescheduled to November 17th, pending the outcome of any evaluations that are done, so that we can determine what's the next steps to take in your case. Your attorney will be in touch with you shortly to discuss the options that you have. Thank you. Deputy, that concludes that case.
Okay, I have a question. Do we need position number 4 on the competent calendar or either position number 22?
Position number 4 on the competency calendar, Antoine Barbary, is reset to November 10th.
Okay.
What
What about position number 22?
22? A transportation order will be issued. Most likely he'll be picked up and transported next week, but it's reset to December 15th for a status.
Okay. Okay, and I'm gonna go grab Wabibi for the SAP calendar, and I'll be coming.
All right,
back.
we have Mr. Green and Mr. Wabibi.
Right, but I can't bring but one person at a time because.
Understood, understood. Okay, Miss Helen, you are next in line for Mr. Wabibi.
Thank you, Judge.
While we are waiting for Mr. Wabibi to appear, Bianca Pache.
Hi, yes, I'm here.
All right, you need to start your video.
Hello.
All right. Miss Pache, okay, good. This is case 21 CR 005586J. Bianca Pache is accused of battery domestic violence from October 16, 2021, in which Miss Pache has apparently made bond, but a bench warrant has since been issued against her for failure to appear in court. And let me get the details of that date. The bond was forfeited on September 28, 2022, after she failed to appear before Judge Besson in courtroom 3D. Notices were sent and returned on October 13, 2022. We have a current address. Well, we had a previous address of Sonwell Way, but it looks that since then the address has been updated to a Grayson Way. All right, Ms. Pache, you have a right to remain silent. Anything you say in open court, the statements can and will be used against you. You have a right to an attorney. And Ms. Helen, are you representing her?
I am, Judge.
All right, Ms. Allen, is there any objection to setting aside the bench warrant before I move forward?
Could you just explain to me the basis for setting it aside at this point?
All right, so I just wondered whether y'all had done your preview, but if not, all right, Ms. Helen, you're next.
Yes, Judge. So basically, our motion or our statement to have the bond petition, or excuse me, the bench warrant set aside is, number one, I believe, did you say the court date she missed was September the 28th of this year, Judge?
No, plea in arraignment, yes, plea in arraignment was September 28th, 2022. And she did not appear. Bond was forfeited that same day.
Correct, Judge. I have already spoken to Ms. Pache. She no longer resided, but had just recently moved from the 2814 Sonley Way, Alpharetta, Georgia address at the beginning of September. So she was not going to get the update. I have the Alpharetta address as the Grayson Way, the most update address. I have spoken to Ms. Pache. She knows that it is her responsibility to update the court at any time, Judge, that she does move. However, Judge, she has been working to get into some inpatient treatment treatment at the same time that she missed that court date, Judge. She was near Valdosta seeking some inpatient treatment to support herself, Judge. She's 32 years old. She was released after serving 17 days, Judge, and it would be extremely detrimental to have Ms. Pache turn herself in on this warrant. She does have some college, Judge. Again, she is working diligently to get into that inpatient program, to follow her bond orders. And this was, again, the first time mistake of failing to appear. I asked this court to set aside her bench warrant, give her another opportunity, again, to respond to any court notices she gets, Judge.
All right. And is the public defender's office going to continue representing her from this point onwards?
I spoke to Ms. Pache. She does still qualify for our services even after having bonded out.
All right. Ms. Pache, are you planning to use the services of the public defender's office, or are you obtaining your own attorney?
Yes, ma'am. I plan to continue.
All right, thank you. Ms. Allen, any counter to setting aside the bench warrant?
No, Your Honor. Just to be clear, though, court notice was sent to the address provided in September on the 13th. And then on the 28th, she missed court, but had not updated the court on a new address because sometime in September she moved.
The only time that I see an address change was after the bench warrant was issued.
Right. But what Ms. Helen is saying is that there was a move that this defendant made in September and just didn't notify the court about it.
That's what I understood.
Okay. And she had been ordered to be released to Atlanta Behavioral Medicine.
Yes.
Is that where we sent notice to?
No, the address
That
would
was
have been sent to the
2021.
Sonali Way, but that was the
Correct,
only
Judge.
address we had.
Correct.
Okay. And so the new address that has been updated after her bond was forfeited, that's where she is going to be. And she understands now to update the court if she moves again, not after a bench warrant is issued.
I hope so.
Correct.
Ms. Pache, do you understand that every time you change your address, you have to notify the court? We are the first folks that have to be notified.
Yes, ma'am.
Because if I don't agree with your attorney, I'm going to ask that you surrender yourself to the Fulton County Jail and be booked at the jail again.
Okay.
And stay there until you make bond, just because you did not update your address.
Okay.
I'm going to, yeah, okay. I'm going to say
apologize.
this, Ms. Helen, go ahead and submit a proposed order setting aside the bench warrant, reinstating her bond with the understanding that she must comply with all laws, no illegal drugs, no alcohol, no weapons, and to always maintain a current address.
Understood,
Excuse me,
Judge.
Judge.
All right.
She was informed of that court date on the 28th by her pretrial officer on the 22nd.
Oh, wow.
She explained that she understood and that she was to report to court because prior to that she missed her pretrial appointments, and so she was informed.
Is she still with pretrial?
No, Judge. After the bench warrant was issued, pretrial closed the case. But she was aware of that court date and that she missed her pretrial meeting.
My goodness.
In
Ms.
that
Pache,
case,
do you?
we
do
believe
you
there's an
hear-
issue.
Yeah, do you hear what we are hearing, Ms. Pache?
Yes.
Do you have anything to say? Well, no, don't answer that. Ms. Helen, do you think your client has anything else to add? Oh.
No, Judge, I will be submitting that set aside. And again, I believe Ms. Pache understands the seriousness of not attending these court appearances in the future, Judge.
One more time, if she does not appear in court again, the next time she will be sitting in jail waiting for her trial date.
Understood, Judge.
She won't be sitting in the comfort of that car. Nothing to smile about, Ms. Pache. I still have a right to vacate my order and direct you back to jail.
Okay.
All right, thank you.
Thank you, Judge.
Mr. Wabibi at the Fulton, is that correct?
Yes, position number 25 and 26.
Thank you. This is, Francis Wabibi, case number 22 CR 006-427E, accused of loitering and prowling and willful obstruction of an officer from September 20th, 2022. Second case, 22 CR 006-428E, accused of loitering and prowling and willful obstruction of an officer from September 21st, 2022. Mr. Wabibi, you have a right to remain silent. Anything you say about these cases, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. We are going to have a non-negotiated plea hearing in which the prosecution is first going to give me their recommendation, and then I will hear from your attorney. After that, I will make a decision as to which recommendation I will accept, keeping in mind that I also have a right to disregard the plea offer and schedule the case for trial. Ms. Ellen?
Thank you, Your Honor. So Mr. Wabibi does have two cases. They are separated by a single day, so September the 1st or 21st and 20th of this year, both for loitering and prowling. This is Georgia Tech campus. The offer in this case is to have both of the sentences be concurrent and to plead guilty to one count. 12 months is the offer, serve 74 days. He'll get credit for 37 days he's already served. And I believe the issue is that we'd be asking for the balance of this sentence to be probated rather than suspended and a stay away from the incident location,
And is there a requirement for community service?
Nope, I do not see one.
There's a 40-hour community service with position 25 that I received with the offers.
Let me see. I see that too. But also null processing the remaining count. So one count of loiter and prowl on each case. And yes, additional 40 hours of community service.
So I'm a little confused. He has the same charges in two separate cases, 2 separate days. Are we
Yes.
going to null process one of the cases?
No, I believe he's charged with loitering and prowling and willful obstruction. We would be
Right.
null processing count 2 and he would be pleading guilty to count 1 in both cases.
I see. So he's, okay, got it. Miss Helen, what is the non-negotiated portion?
It's the balance probated in the community service. When I went and spoke to Mr. Wabibi, he understands about not going back to the Georgia Tech campus, but there was no violence asserted towards anyone. I think the obstruction was him trying to leave away from the officer, Judge. And so we would ask that this be time served, which we did agree on with the state, but balance suspended with the condition of not going back to Georgia State or Georgia Tech campus, Judge, specifically Georgia Tech, Judge. I have also spoken to Mr. Wabibi. He's residentially challenged. So the probation and reporting and the community service, I don't believe that would be a successful option. What I would like to do is, if it is balance suspended with the condition of entering Gateway Center, I have given him a flyer, the contact number, the address of Gateway Center. He is more than willing to enter that center, enter that program for assistance with housing, with shelter and food, Judge. So I would petition the court to, again, be time served, balance suspended with the condition of entering Gateway Center.
All right. I have a Shayna Wabibi who is present.
Correct, Judge. I believe there's a brother and a sister. He does have strong family ties here to support him on the call for him.
Okay,
And
good. Can Ken Wabibi or Shayna Wabibi come on the video, and I need them to address the court. Mr. Ken Wabibi? Shayna Wabibi.
Hello. How you doing?
Fine, thank you.
Hello, Judge.
Mr. Ken Wabibi, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
How are you related to Francis Wabibi?
Francis' older brother.
You're his older brother?
Yes.
And why is he laughing at you? Is there a mental health issue?
Judge, but I also think Mr. Wabibi is excited to see his family on the call.
Well,
I don't
he's not
believe
gonna be
he's laughing.
excited after I'm done. So. Mr. Wabibi, Mr. Ken Wabibi, what is your brother's residential status? With whom does he live?
Well, we're not sure who he lives with in Atlanta. We've been trying to stay in communication with him because we live in Charlotte, North Carolina. And we had always, when we get in the phone call with him or talk to him via email, we always express, hey, if you're having problems in Georgia, you can always come back home to Charlotte. You can stay with us rent free, get back on your feet, go back to school. That was always an option given to him. But for some odd reason, he hasn't taken the option to come back home to Charlotte for some odd reason. Like me, myself, and my mom expressed the same sentiment, saying, hey, if you're having issues in Atlanta, just come back home to Charlotte. There's no issue to start back over. You could just stay home, find a job, save your money, go back into school, and then support yourself afterwards. But he hasn't.
Well, I've been told he's homeless. So I'm looking at his family out there, but he's wandering around Atlanta residentially challenged. So I'm really concerned what kind of family support there is.
Well, he has no family in Atlanta. We're all here in Charlotte, North Carolina.
Understood.
Mm-hmm. And he has chosen to go to Atlanta for some reason. I'm not too sure why.
Okay.
But we always expressed to him that he could always come back home to Charlotte and stay with us.
Okay. Thank you.
Mm.
Ms. Shana Wabibi, did you want to add anything else?
The only thing I would add is that he definitely has a strong family.
You need to solemnly swear and affirm the testimony you provide will be the truth.
Yes, ma'am. I do solemnly swear that.
So he has what now?
I just wanted to say that he does have a very strong family support. I know the last time we went to his court date, it was some time back, but it got rescheduled to this court date. And as my brother said, that we're from Charlotte, so we heard that his court date was going to be at 9 a.m. So we left early in the morning, around maybe 4 or 5, just to get there at 9 a.m. But we found out that it was rescheduled. So we've been trying to make efforts to get in contact with him. And you can see on record, I've been trying to video call him multiple times. I want to say 5 times, and I wasn't able to get in contact. I don't know for what reason, but that's why I decided to come to the court today, just to be able to see him, because I haven't seen him for months. But just like he says, like, he's always welcome to come back home. My mom always stresses that. She even wanted to come to the court today because I was told that he could possibly get released, but we weren't sure what time that he would get released. And so it was kind of hard to kind of gauge what time to get there, whether he was going to be released today or tomorrow. But if he were given a time, we definitely would have been there to pick him up. So he definitely does have a strong family support. I just wanted to testify to that.
All right. Thank you.
You're welcome.
Yes, who wanted to speak? Miss Ellen or?
I was just going to say, I'm glad the family members had the opportunity to speak. They are willing to come here to give him a ride to wherever back home or wherever he would want to go, Judge. So his family is willing to show up to be that transportation for him and show up as his family. I am again petitioning this court for time served, balance suspended, either released to his family, which they're willing and able to take the drive and show up.
I don't think the plea offer, as the defense is seeking to have, is adequate. I'm concerned about Mr. Wabibi's behavior. I don't know if it's pleasure or happiness to see his family, or he just really does not grasp what's happening at the present time. And that behavior right there tells me he does not grasp what's happening at the present time. The request for a plea offer is denied. I'm going to reset the case to November 3rd. Ms. Helen, you either need to get with the family and consider some MHET situations, and I would consider a plea offer if he has a definitive address, an opportunity for MHET, and some assurance that he would maintain a schedule with probation. Because right now, I'm just watching him on screen and he's muted. I don't believe that he has an ability to grasp what's going on.
Understood, Judge. You said that's a reset to November 3rd?
Yes,
That'd be the SAP calendar?
yes.
Thank you.
And this is not a competency referral or evaluation request?
Unless Miss Helen, if you get a social worker to evaluate him and determine that he should not be on the SAP calendar. Mr. and Miss Wabibi, I have serious concerns about what we call MH issues. If you want to reach out to his attorney, Catrice Helen, and she can tell you what exactly do I mean without violating any HIPAA rules. Position 25 and 26 is not going to be a plea. It's going to be reset to November 3rd as directed. Thank you. Courtroom 2, who do we have?
On a competency calendar, we got Mr. Barber.
This is Antoine Barbary.
This is.
Yeah, Mr. Barbary, my name is Judge Long. Please remember you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Mr. Derek Howard will be in touch with you to discuss the options that are going on in your case. Your case will be next addressed on November 10th, once we have an update on the status of your situation. Thank you. All right. That was the only case that I had left. Was there anything else to address? Courtroom 2? Repeat, please.
Banfield.
8 and 9.
8 and 9. Okay. Mr. Green.
I have position 22 on the competency.
Okay, give me a moment. Do you have Mr. Green, position 8 and 9?
Green is on 3 north.
Walter Green?
Green is on 3 north. I believe Black went to take on the other guy back to get Green.
Okay. What was the other case that you wanted to inquire on the competency?
22.
22.
No, I wasn't stopping her.
I think didn't we already inform Mr. Pamphile? His case is, I think we already informed him that a transportation order will be issued and the case is reset to December 15 to make sure that he's transported to his next location.
Okay.
Any other matters?
No, just Barbary. You done with Barbary?
Yes, we are.
All right, thank you.
Thank you. All right, I'm just going to go over down the calendar on while we are waiting for Mr. Green. On our DV bench warrant calendar, Bianca Pache, we're going to set aside the bench warrant, and Mr. Helen will send the proposed order to April Champion. On the state all-purpose calendar, position number 1, Carmichael is arraigned and further notice for trial. Position 2, Cole was a plea. Position 3 was a plea. Position 4, De La Rosa is reset November 17th on the competency calendar. Position 5 and 6 were pleas. 7, Gaffney was a plea as well.
I apologize, Judge. Position 7 was a plea?
Yes, Gaffney. Position 8 and 9, Green, are pending. Position 10, Hammonds was arraigned and further notice. Position 11 and 12 were pleas. 13 is reset to November 3rd, SAP calendar. Position 14 is reset to December 1st, competency calendar. That's log on. Position 15, Lucius was a plea. 16 was arraigned and further notice to November 3rd. It has been arraigned and further notice to November 3rd for a bond consideration. Positions 17, Myers is reset to November 1st for conflict counsel to speak to Mr. Myers. Position 18, Anthony O'Connell is reset to November 2nd. Position 20 was Mr. Darrell. Yeah, November 2nd would be the incorrect date. Position 18 would be.
I apologize. This is the third
Oh,
judge. I apologize.
That's okay, that's okay. Position 20 was released on October 24th, and that's further notice for trial. Position 20, Price, was a plea. Position 21 is arraigned and further notice. Position 22, Robinson, was a plea. 23 is arraigned and further notice. Position 24, Thomas, is arraigned and further notice for trial. Position 25 and 26, the plea offer was rejected, reset to November 3rd for further consideration, possibly to be reset to the competency calendar, depending on the evaluation or a social worker interview. Position 27 was a plea. So we are just waiting on position number 8 and 9 for Mr. Green. Mr. McLean, have you conferred with Mr. Green?
Yes, Your Honor.
Right, so that's going to be a negotiated plea hearing, correct?
Yes, Your Honor.
All right, we'll be in recess until Mr. Green appears. Thank you. Miss Helen, I see Shayna Wabibi is still on the Zoom. If you want to send her the contact information so that she can reach out to your office to get the information, that would be great. Thank you.
Understood, Judge.
Mr. Green available?
All right, we are addressing position 8 and 9 on the SAP calendar. Good afternoon, Mr. Green. My name is Judge Long, and please remember, good afternoon. Please remember that you have a right to remain silent. Anything you say in open court, the statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Do you see Mr. McLean on the screen? Mr. McLean, if you could wave your arm in front of you. Do you see it?
Yes,
Excellent.
ma'am.
Thank you. All right, Mr. Green, you have two cases before us, 22 CR 006-907J, in which you are accused of simple battery domestic violence from October 14th, 2022. Your second case is 21 CR 007-300J, in which you are accused of disorderly conduct and simple assault of domestic violence. This is going to be a negotiated plea hearing in which, Mr. Green, the prosecution is going to give their recommendation, and then I will hear from your attorney in order to determine whether you're going to enter a free, knowing, and voluntary plea to these particular cases. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Allen, this is going to be a global offer for both cases?
Yes, Your Honor.
And they are?
To run concurrent. So that is a 12-month sentence with 60 days to serve. The defendant will get credit for the 14 days he's already served, and the balance is probated. He's to complete family violence intervention programming, to have no further contact with the victim, to stay away from the incident location, 1605 Stokes Avenue, and to complete 20 hours of community service.
And who is the victim in that first case?
The victim in both cases is Laura Gibson.
Okay. All right. Thank you.
Yes, thank you.
Mr. McLean?
Your Honor, after discussing the pros and cons and risks, he asked the court to accept the negotiated plea.
All right. Mr. Green, have you consumed any medication or alcohol?
Yes, ma'am.
All right, and after consuming that, I'm assuming it's medication, are you still able to understand the proceedings?
I don't understand, ma'am.
All right. If you don't understand the proceedings, it'll be very difficult for me to move forward.
Yes, ma'am.
All right, do you need to speak to your attorney longer? And
Yes,
address
ma'am.
this plea offer another day?
No, ma'am.
All right, Ms. Grace, if you could place Mr. McLean and Fulton in a breakout room, please.
Okay, Judge.
We'll be in recess until Mr. McLean has conferred with his client. Mr. McLean, please don't take too long, okay? Thank you.
What they're doing now.
Hold on.
Deputy, there may be a message on the screen to join a breakout room. Okay, she got it. All right, Mr. McLean?
Okay, we're back, Your Honor. I think it would be best to put him on a competency calendar. We'll see if his latest evaluation is recent enough. And he thought he could make it through today and understand everything, but I think he's a bit confused, and I think it'd be better to go that route.
Okay, I can put him on the November 3rd CC calendar.
Very good. That'd be great.
Mr. Green, we will see you on November 3rd. Thank you.
Yes, ma'am.
Yes, Ms. Allen?
Thank you.
Okay. All right, Mr. McLean, we have gone over the calendar with Ms. Helen, and I believe with you as well. So do you have any other questions about the calendar?
No?
All right. Ms. Helen, you've reached out to Ms. Shauna and Ken Wabibi.
I apologize, Judge. Can you repeat that question for me?
Reached out to Shauna and Ken Wabibi.
I
with
have,
your
Judge.
appointment. Okay, excellent.
Thank
All
you.
right. If there are no other matters, then thank you very much, everyone. We will see you at the 2 o'clock calendar then, for some of you lucky enough to do this again. Take care.
Thank you, guys.
Thank you, Judge.
Thank you.
Thanks.